Okay, welcome everyone. I am Tony Curtis, the Interim Executive Director of the Metropolitan Housing Coalition. And thank you for joining us this evening for tonight's panel discussion. MHC is a 32-year-old organization with over 300 individual and organizational members, which include community housing advocates, neighborhood activists, financial institutions, local government agencies, nonprofit developers, labor unions, and many more institutions and people who advocate for a fair, affordable, and accessible housing. Our coalition forms the united voice for fair, accessible, and affordable housing in Louisville and has done so for those 30 years. You can become a donor member of MHC and support panel discussions and virtual events like this by going to metropolitanhousing.org/donate. Your support helps make these programs possible and free and open to everyone. Tonight's panel will focus on understanding Kentucky's new housing conservatorship law. Our panelists will discuss several issues. What does the law mean for repurposing and accessing Louisville's vacant and abandoned properties? What are the legal ramifications of this legislation? In what ways might the new law help improve quality of life in neighborhoods with high levels of vacant and abandoned properties? And what potential pitfalls might homeowners and other residents need to be aware of as the new law is implemented? Our panelists tonight are Laura Grabowski. Laura recently became the director of the newly combined Louisville Metro Office of Housing and Community Development within Develop Louisville. Laura has been with Louisville Metro since early 2009, working in affordable housing and community development. She has spent the last 5 years leading a team working on resolving vacant and abandoned properties with programs such as foreclosure, demolition, the land bank, and conservatorship. Our next panel is Ben Carter. Ben Carter is Senior Litigation and Advocacy Counsel for the Kentucky Equal Justice Center. Before joining KEJC in the fall of 2018, Ben litigated individual and consumer class actions at Ben Carter Law. From 2008 to 2010, he worked at Louisville's Legal Aid Society and helped Jefferson County build an innovative countywide response to its foreclosure crisis. At KEJC, he litigates cases, lobbies policymakers, and works with communities, organizations, and government agencies to ensure all Kentuckians live within fair systems. And our third panelist is Melina Hettiaratchi. Melina is a family and education law attorney in Louisville and Jefferson County. Originally from Montgomery, Alabama, Melina moved to Louisville in 2019 after graduating from Mercer University with a degree in early childhood education and special education in 2015, and subsequently a JD from the University of California Hastings College of Law. Melina quickly sought opportunities to serve her new hometown, working as a legal fellow at Global Game Changers, an after-school enrichment program, primarily serving West End elementary schools, and taught kindergarten to a pandemic pod group in her neighborhood. She has recently opened her own practice in downtown Louisville to provide family and child advocacy in areas including divorce, custody, dependency, school discipline, special education, and more. She is here tonight as a volunteer member on behalf of Food in Neighborhoods, a community coalition that supports community efforts to build a just, healthy, sustainable food system in Louisville, Kentucky. So thank you to our panelists for joining us tonight. Before we get started, just a few quick reminders. We encourage you to ask questions through the Q&A function at the bottom of your screen and to participate in a lively debate in the chat box. We will get to as many questions as we can tonight, and if we do not have a chance to engage your question, we will follow up with any unanswered questions on MHC social media and in our January e-newsletter. So follow us at MHC Louisville on Twitter, Facebook, and LinkedIn, and sign up for our newsletter to follow up on these important questions. So we'll open tonight with our first panelist, Laura Grabowski. Laura, the platform is yours.
Great. Thanks, Tony. It's great to be here. I'm glad that we're having this panel discussion about a new law that goes into effect in about two and a half weeks. We're pretty excited about it here at the city, and it's exciting to share. We're still working through some of the details of the brand new law, so we may not have all of the answers to questions, but we are we'll be happy to give it a try. So I just wanted to do a bit of an overview of the conservatorship law and the strategy that the city is planning on using to implement the law. One thing about conservatorship is that it is a law that can only be used essentially by the city. And what that means is, in order to petition the court to have a property put into conservatorship, that petition has to come from the local city or county. In this case, it would be Louisville Metro government. So let me back up a minute. So Louisville Metro government, I think, I'm trying to remember, Tony, we had a VAP 101 session, and I want to say it was at the beginning of this year, but every year now feels like a decade, so it could have been 3 years ago, but I think it was earlier this year. And in that session, we went over a variety of strategies. So I just want to set the stage a little bit to say that conservatorship is not the only strategy that the city will be using. We will continue to use all of our other strategies that we talked about earlier: foreclosure, demolition, the land bank, code enforcement, lien waivers. There are a lot. But the question for us is, when is, how to basically how to match up the strategy with the right property. And so that's why we're pretty excited to have this new tool. We consider it one of the tools in our vacant and abandoned property toolbox. So conservatorship is essentially I think about it as guardianship for children or elderly people. It's a little bit like that, but for houses. And we have houses that have been abandoned for a variety of reasons. There's no requirement for an intentional abandonment. That's not something that anyone's looking for. Someone could have passed away and there are no heirs, or there was no will. A corporation could have dissolved. I mean, there's a story for each and every vacant and abandoned property. So, but regardless of how it was abandoned, it's causing problems for the neighbors, for the street, for the community, and also for the city, because it is using resources to cut the grass and board, that sort of thing. So anyway, the tools that we had before conservatorship, now let's just take foreclosure for an example. The city could use code enforcement liens to initiate a foreclosure case that's very similar to what would happen if you don't pay your mortgage. The bank petitions the court and starts the foreclosure case. But just like in whoever initiates the foreclosure case, the important thing is that the ownership doesn't change until the very end, until it goes to the commissioner's sale and is sold to the highest bidder. So when that happens, in foreclosure, nothing can really happen with that property until that ownership changes. The city sometimes will go in and demolish properties. We try very hard not to do that, unless the property is, is dangerous or is just too far gone. But other than that, there really isn't anything else to do. So we have neighbors calling the city and saying, this house is scary. It's open. You've come and boarded it, but it's still not great. I don't want my kids playing around it. And there's not a whole lot that we can do except put the property in foreclosure, wait, 9 to 12 months, because we've got to go through a process. And then hope that it gets into some responsible hands, or hope that the land bank gets a hold of it and can, get it into responsible hands. But the point is that while that's happening, the property is sitting and deteriorating. So conservatorship gives the city, gives the neighbors, gives the community a way for that property to be rehabbed before, in the middle of essentially that process. So I have put together a process flow to show you all, because I know this can get really complicated, and I'm actually not an attorney. I just play one on Zoom, but it is complicated. But essentially, the idea is you have an abandoned property. The city says, hey, maybe it has some historic value, or maybe we just, don't want to see it go downhill anymore. Maybe we're getting a ton of information from neighbors that this property could be saved, could be a great house for, a new owner. And so the city will go and petition the court and say, hey, we want this house to be saved. We want to put it in conservatorship, again, like a guardian over the house. Here's our plan. Here's who we want the conservator to be. You know, they need to be experienced. Here's our timeline. Here's some, even the fact that we have, you know, funding to do it. And then the court, you know, holds the hearing and at some point puts it into conservatorship, and then work can happen. I'm abbreviating this process, obviously, but work happens. And then at the end, the conservator can go to the court and recommend that the house be sold, either through a public auction, like what happens at foreclosure, or, you know, perhaps they have an owner or a buyer already in mind, or they want to market it privately. Like, that's not necessarily determined by statute. The court will accept they'll listen to a recommendation of a conservator. So let me stop talking for a second, because I know that's a lot, and let me pull up this visual. I think it might help just to sort of see the process on it. Okay, I'm hoping that you all are seeing the screen with highlights at the bottom. Can I get a nod from some panelists? Yes, okay, good, all right. Okay, I'm not gonna go over the slide again, but this was actually a slide that we used in the VAP 101 earlier this year. So just as a reminder of how many other strategies we have, but this one highlighted at the bottom is the one that we're talking about today, okay? And we can send this out because I think it's a pretty helpful slide to remember what the goals are for these different strategies and, you know, what happens as far as ownership and that sort of thing. I'll come back to that second one. Here's the process, like we were talking about, okay? You know, the properties are going to be recommended to us. We're going to take a look, what's historic, what's out there, what's abandoned. We're going to determine, you know, whether they're eligible, and we'll go back to that in a second, and appropriateness. We want to take care of as many of the liens as possible on that, and that will matter at the end when we're going to sell the property and try to pay everybody back for what they're putting in the property. The city's going to file the petition. We already talked about the fact that the petition is going to include a lot of this information. The conservator then, the court holds a hearing. What am I doing? Look at this arrow. I'm so sorry, you all. Look, 1, 2, 3. Let's just forget the arrows. Let's go over here. Oh my goodness. Hold on. Now I'm all jumbled. This is terrible. Oh, right. Okay. Forget the numbers here. So notice is provided. The court holds a hearing. If the court grants a petition, the conservator is appointed. That conservator has to be an entity with rehab experience. How is the city going to decide on conservators? First off, we're probably going to use the land bank for our first couple. The land bank exists. We don't have to worry as much about funding gaps. But eventually what we want to do is to put out a call for conservators. We expect nonprofit housing providers, for-profit housing providers, people with affordable housing experience. We've already received a lot of calls and questions from that group. But essentially, a conservator per the statute just has to be an entity with rehab experience. Once that's approved, all of that work can be done. The conservator has a decent amount of authority that's granted through the conservatorship. So they can hire contractors, they can take out debt, they can, you know, do work, they can enter the property, all of those types of things. They continue, they fix it, they get it up to a standard that is sellable. And then, like we talked about earlier, they go to the court and say, okay, we either, you know, we have a buyer, we want to put it out for the private market for sale, we want to do a public sale. So you're noticing here that the conservator is not necessarily going to be the long-term owner. Again, just like that guardian of a person, it's not, you know, we're not talking about full-on adoption. We're talking about, we're coming in, we're taking care of it because the owner can't or won't or whatever, for whatever reason, isn't taking care of the property. And so we want the property, we want to prevent demolition, we want to, you know, keep the neighborhood whole, we want to improve the property condition. And then this at the end has to do with, you know, who's getting paid. So the conservator does have does have the ability to charge a bit of a fee for their time. So before, I don't want to take up too much time because I want everybody else to be able to have a chance to speak, but just take a look at this. I won't read the whole thing to you all, but this has to do with what properties can be, are candidates for conservatorship and which ones are not. And I think this is really important. You know, we are not talking about properties where someone has, you know, gone on vacation, or someone has relocated and they're trying to sell their property, or, you know, grandma's in a nursing home and the family's trying to figure out what to do. These are not the properties we're talking about. And we are talking about vacant and abandoned properties. Louisville has plenty of them. We don't need to go outside of our lane to find other properties. There are plenty of these to work on. But you can see here, you know, has it been actively marketed? I mean, the statute has a lot of criteria in place that it has to meet. You know, are there building code liens that no one's responding to them, no one's fixing them? You know, what kind of property? We're talking about buildings. You know, how long has it been vacant? I mean, these are the properties. You can get a picture in your head of what these properties look like. What the city wants to do, and what we're planning on doing, is taking, you know, the list of the vacant properties that we already know about, because neighbors contact 311, and that's, you know, we get information from codes. And we'd like to take a look at, you know, are there any in historic areas? Are there any that are historic that we can, you know, start moving on, that we've not been able to do anything with, and we're worried. I mean, we've lost quite a few properties over the past few years to emergency demolition that had a lot of historic character, and that's not something that that we want to do anymore. But we haven't really had a lot of choices, so that's something that we're going to start. We're looking to do, I mean, maybe 3 to 4 this first year. We want to get things through the process, figure out where the, you know, the kinks are, figure out how to make this work. You know, at best, if we could get it moving, we're probably talking about 8 to 10 a year. So this is not going to be thousands or hundreds. We hope it's successful. We want to use it, as I said, as a tool within the toolbox that we have for other strategies for vacant and abandoned properties. With that, I will stop talking for a minute and hand it back to Tony.
Thank you very much, Laura. We will move on to our next panelist, but please do keep the questions and comments coming in the chat and in the Q&A part, and we'll definitely get to those questions. But I'm going to turn it over to Ben Carter now, and the platform is yours.
Thanks, Tony, and thanks, Laura, for that really helpful overview. I'm going to keep my comments very short and simply say that, like I'm saying in the chat right now, there's a lot of unknowns about how this will work in Kentucky. There are other states that have conservatorship statutes, some more aggressive, some more conservative than, no pun intended, than our own conservatorship statute. But this one, you know, the important thing for folks here to understand is that it's not a free-for-all. Only the city or county that the property is in can pursue this kind of action against a vacant and abandoned property. So it's not like private developers can themselves go in and lay claim to this. The role that KEJC has, or what I want to say to this group on this call, the VAP nerds of Louisville, I guess we can say, you have to be a really special type of person to be on this call at 5:50 on a Tuesday night. So I want to applaud each of you for you know, achieving your true nerd potential on this in this area. So the thing that we need to be concerned about or be watching is, how does the city engage with neighborhoods to make sure that neighbors' interests are protected? One of the things that, if you look through the statute itself, you will learn is that there are only really three kinds of people that are what are called real parties in interest. These are the people who have the right to be in front of the court in the first place. It's the owner of the problematic property, it's the city or county, and it's the lien holders, any lien holders on that property. The statute requires that the city or county provide notice to any property owner within 500 feet of the affected property. But the statute also specifically does not give those people the status of real parties in interest. So the neighbors who have been most affected by the vacancy, the blight, the abandonment, do not have the right to go to court and argue about who should be the conservator, whether the property should be demolished, all of those things. And so it really is up to the advocates on this call, the community members on this call, to insist that the city sets up processes that gives voice to the neighbors' concerns, not just the 500 feet neighbors that are required to get notice, but also what's the plan for community engagement. I know that Laura and her team are thinking through those things and setting them up. And by starting small, we have the chance to not be so overwhelmed with volume that we can't do this kind of outreach and engagement right. But as the city targets these 7 or 8 properties, we need to be making sure that we have some processes in place for neighborhood voices in this. So that's essentially what I'm going to be active in the chat. I want this to be a real learning session because I know we have a lot of smart people who are not panelists here, right? But that's all I wanted to really say to the whole group is what's the transparency strategy? What's the community engagement strategy? How can the city provide notice under the statute that's even above and beyond what might be required by the statute? So can we set up a website where, the city gives those neighbors an opportunity to ask questions or engage, find out more information, all of that stuff. So I'll be active in the chat, and I'm sure I'll have more to say as we have more questions, but I'll pass it on.
Very good. Thanks, Ben. We are definitely getting a lot of activity in the chat, which is great. Keep that activity coming and the questions coming. And just quick note, Laura, is the process outline that you were sharing, is that available publicly before we get on to Melina here?
I just responded to Maria. There is a website on louisvilleky.gov where it is coming and it says coming soon. So I was hoping to get that up by today, but we'll get it up in the next couple of days. And it's on a link. I can put it in the chat of all of the strategies, and then each strategy is supposed to have its own page. That's why it hasn't gotten there yet. So
that would be great. Thank you, Laura. And now let's go to our third panelist, Melina. The platform is yours.
Hi, everyone. So I'm here representing Food and Neighborhoods, and primarily we talk about what the vacant land will do or what property owners or these conservators could do with the land on their property. Clearly, the statute is really focused on buildings, and the priorities is really what we do with the buildings and the structures on these properties. But there is mention of the land appurtenant, meaning next to the properties that have been identified. And one priority Finn has, and a lot of we're a community coalition, and a lot of the coalition members have been bringing up, is how do we use this conservatorship model to also amplify green spaces or urban agriculture, and stop penalizing these neighborhoods with code enforcement for weeds when it's actually growing your own food in your yard. Things like that. We are also right there with Ben and so many more advocates on expanding what is a party of interest, first of all. And from the very beginning, how do we notify the people who have the highest interest and the most impact on their day-to-day lives? Long-term renters, any renters, neighborhood members, community organizations. It specifically says a conservator can be a nonprofit, but the nonprofit has to have the mission of rehabilitation, blight abatement, things like that. That excludes organizations that if you don't have a community development nonprofit in your neighborhood who really can step in for that neighborhood. So things like that, how can the city kind of go above and beyond what the statute does? The statute clearly has some good intentions, and I've heard lots from Laura that are really good intentions within the department, but what can we do to make sure that we can stick to those? So from the very beginning of service and process, and here's the lawyer that I'm not really sure I'm happy she's coming out, but here's the lawyer coming out with service and process and notice. How do we expand those parties and expand those mechanisms? But even after that, when the city makes recommendations in the petition for what happens on that property, what's that process look like? Where do those recommendations come from? How is the community dialed into that? Can we have the community voice baked into every recommendation and every petition that goes forward? Things like that.
Okay, thank you, Melina. We have lots of questions coming through right now, and I think let's start with the issue of parties of in interest. There is that question of, can it be interpreted in a way that it might be expanded? Is there any insight from the panel on how that might be done?
I mean, one thing we were thinking about, and this is where me not being a lawyer can be helpful or not, is that even though the statute requires, so the statute requires notice to property owners within 500 feet of the property that's being petitioned for conservatorship. And then, as everybody said, they list the parties in interest. I don't know that the court would be opposed to hearing from neighbors. And in fact, I mean, if I were a judge, I would want to hear from the neighbors, at least about their experience with the property. They probably have more experience than anyone over the owner. So that, from our perspective, the city's perspective, I mean, whatever kind of engagement we can do and education or anything we can do with the court to let them allow that, or I don't know if that's the right word, I think we're willing to do. I know that I'm rambling a little bit, but I don't think the statute precludes that. It's just that, it names parties in interest, and these are who those people are. I can imagine the vast majority of these cases, no one in that list is going to show up at this hearing. I mean, the city will be there. There won't be other lien holders because the properties can't have a mortgage on them. And then the owner, if the owner would have shown up, they probably would have shown up somewhere before this process starts. So again, I mean, if I'm a judge, it would be nice to hear from neighbors to say, hey, I think this is a good idea, or I don't think this is a good idea, or whatever, kind of evidence they want to have.
Or anyone else before we? And let's get back to kind of how, I mean, the Louisville Metro process, but also the state process for defining this law. Are there similar laws being enacted in other states? And did Kentucky or Louisville look to other municipalities in the ways in which we are enacting conservatorship in Louisville?
Right. So, I mean, from our perspective, we literally, the people who work on my team had been hearing about this in conferences going back years. Sometimes it's called receivership, conservatorship, and we were very interested in it, and we were extremely overjoyed, really, when the Kentucky League of Cities actually took this on as an advocacy piece. It started before COVID, and then the beginning of COVID kind of shut that down. So we were glad to see it come back in the regular session. So we certainly had, some input, but we didn't draft the legislation. This was something that, that KLC really saw that we needed. It looks like over 20 states have some form of this, and to the points that were made before, some of them, are extremely I mean, there's just all kinds of varieties of this thing. So there were some, I think, decisions made obviously at the state level to keep it, fairly conservative, which I think will work. I think it'll benefit. Will there be changes down the line once we, get through this? Possibly. But I wanted to clarify that it's certainly not Louisville's law. It was definitely a statewide effort, and I'm not sure what other cities are interested in using it or implementing it, but I'm sure we'll figure that out at the beginning of the year.
And a question came across about kind of Louisville Metro Council's role. Does the new law present any opportunities or action items for Louisville Metro Council to interact or amend or kind of amend the process whatsoever?
No, it's not. We've had a decent amount of state law changes that enable the council to set something up, but this was really administratively created in the statute. It's not that Metro Council won't be involved. Of course, we're especially in regular communication with our council people, especially the ones that have high concentrations of VAP. So I can imagine that they will have suggestions for specific properties, specific conservators, the outcomes and that sort of thing. But there's not necessarily a role. They don't need to amend an ordinance. They don't need to create an ordinance. There's that sort of legislative role at the local level isn't necessary or anticipated.
I guess that's a clarifier that I have as the new Louisvillian, but also people who don't understand the play between Louisville Metro and like state law is, but couldn't they pass an ordinance that says this is how we will execute it? I know that's common with affordable housing law generally, where if a state, I mean, like Georgia's a really great example, conservative state government said no affordable housing quotas and things like that for your developers. But the city of Atlanta was like, okay, well, how can we toe that and do as much as we can over that to meet affordable housing goals that the city needed? And so I don't know why Louisville Metro couldn't have its own ordinance saying, this is how we're going to do it to protect the communities we're trying to protect. I don't think the statute precludes them from doing that. Is that correct?
Yeah, I mean, no.
Okay.
I mean, Metro Council passes a lot of legislation, so okay. I don't think. Yeah, I mean, like, I don't think anybody's trying to like tie your hands. There was a comment in the chat that was like, well, this is all like this interpretation is bound to basically you and your administration of this law. And what happens if you get something down the pipeline that's like, well, our priorities are different now. Like we want gentrification of the West End. What if that's the new priority? What do you get to do? If the law could be passed at Louisville Metro, then you can always fall back on that. Yeah, it's an interesting question and something that we really haven't thought about. But it's certainly an option.
Okay, there are some questions about how the law will affect property costs. How will implementation of this impact property costs? Anybody have any insight into that?
Sorry, I'm trying to read there's a lot in the chat. I'm glad everybody's chatty.
Is this Mike's question?
I don't know if this is.
Are you talking about the property values, like the neighboring property values? Is that the question?
I think that's a good route to go down. Yes.
So, I mean, this is again where, what do I want to say? With the vacant properties that I won't even want to say that we're looking at, because it's not like we have some kind of secretive list. It's that with the vacant and abandoned properties that will be eligible for this program, and I saw some questions in the chat about this too. They are going to likely need gap funding, right? So, and we have this problem with vacant properties in general. It doesn't matter if they're a conservator, if there's somebody buying from the land bank, or if there's somebody buying at the commissioner's sale. Often with a property, it needs more money, it needs more work than it is going to be able to sell for. So that was one reason why I was excited about this law, because in the vision, we have a property that needs to be rehabbed. We have affordable housing money, and that money can fill the gap and therefore provide a homeownership opportunity for someone in the neighborhood where possibly they're renting or they grew up. And so with that, I would assume that the property values, I mean, for one, we're talking about 7 or 8 a year. So I mean, nothing, the market isn't going to change based on 7 or 8 a year. But even if the 7 or 8 are finished, we're not talking about selling these at an inflated cost. And I don't think that will change with administrations and that sort of thing, because the math just isn't going to work. There's going to have to be some gap financing, and generally that gap financing comes from home funds, affordable housing trust funds, something that's going to make that house and the sale price affordable. Again, that's just my that's my take on it, and that's kind of our strategy. And it doesn't have to be everybody's strategy, but that's, I think, that will put a safeguard in there.
That's something that's come up in several questions about what protections are in place for ensuring that this does not contribute to involuntary displacement in the areas that it is applied, and how can that be codified across? I mean, if there is when a new administration does come in, what kind of protections exist for individuals in these neighborhoods? Which I think is probably part of a larger conversation too, just thinking about, the West End Opportunity Partnership, just thinking about neighbors and especially renters who are already in these areas.
I mean, the way the conservatorship program works, the conservator has to put their own money into the deal, or has to take out debt. So, is there a chance, especially a few years down the road, that someone would want to put, $200,000-$300,000 into something that, has an assessed value of 60 or 70? Sure, we've certainly seen it in other neighborhoods. I mean, I think it's going to take a bit of time. I just don't see that happening soon. Doesn't mean that it can't. But if the question is there a way that this can be codified? I'm sure that there is. I'm sure that there is. I'll leave that to attorneys and legislators to do.
Okay, and how about the thinking about this from Eileen? The notice to neighbors is, per the statute, is to inform so that they can petition to intervene. So what kind of, and this kind of gets back, I guess, what Laura was talking about earlier, is what methods and tools are in place what are you all thinking about as far as community engagement? How are you thinking about formulating kind of that process to engage neighbors in these communities?
The part that we've really been focused on is how to get information from neighbors, about particular properties that they would be interested in seeing go into this. And for us as a city, that's a very similar question that we're continually asking. Neighbors send in foreclosure referral forms to say, I'm tired of living next to this property. Neighbors call 311 on properties. Neighbors call code enforcement. And it's not to say that we're not necessarily planning additional community engagement around conservatorship specifically, but that's really where we've been focusing. It is, what's the property on your block that you know, has been sitting there for so long and you are ready to see something happen with it? Or what's the property that, you know, your grandma grew up in and you've watched it? We have this story come, you know, multiple times a year where I'm watching it and it's deteriorating, and you know, it's maybe a family property from, you know, decades ago, but it's got a hole in the roof and I don't want to see it torn down. So, you know, that's where we've been focused on. But I'm glad to have this panel, and even the pre-panel discussion that we had, because I think there are a lot of good ideas about how and when to involve the community, and even how to you know, make sure that when people are informed and given notice that they know, you know, what they can do, what they should do, you know, what's available to people, because we certainly want to make sure that people have a voice in this.
And then this might be a question that might go to Ben here is, and I'm trying to follow the chat as well, but it may have been answered in there, but the obligation, what is the obligation for the conservator if the property does not sell? And it might be a Laura question too.
That is a good question. I don't know the answer to that myself. I mean, I think the conservator would, again, still have a interest in the property if it doesn't sell in the way that they expected it to when it does. It's not like the interest would go away, but maybe Laura has a better answer.
Well, I mean, I guess the part of the statute that I would get stuck on is, or that I would look to, is that they could do a private or public sale. So my assumption is, if, you know, the conservator isn't, you know, one of our nonprofit housing providers that has a, you know, a list of clients interested in purchasing a home, or something to that effect, that they would just say to the judge, okay, you know, we've rehabbed it, here's how much money we have in it, we're ready for it to go to, you know, for a public sale. And I don't know if the judge would send that to the commissioner, you know, to sell that way, or if they would do it by a different auction. But I'm assuming that's how that would work. But again, I mean, what we really want to see is a conservator that has all the ducks in a row, you know, before they go into this, because it's not something that you want to jump into, put money into, and then not have a clear plan.
Definitely. And let's go back here to, I mean, talking about funding is, I think somebody asked if Laura had said something about using affordable housing funds for conservatorship. And if so, how do you ensure that affordable housing is actually created from using those funds?
So I am not saying that affordable housing money is set aside and dedicated. That's not what I'm saying. What I'm saying is the way the math is going to work out, there is going to be a gap, and I saw some information in the chat about that. So that makes sense. There's going to be a gap, and in most cases, when the city's involved and there is a gap in rehabbing a property versus selling it, that gap is filled by some sort of affordable housing money, whether it comes from the trust fund, whether it comes from the city, THC, you know, wherever that gets filled in. And so that's how then, when you put affordable housing money into a project, there are restrictions on a variety of things related to that. So that is a few steps down the line, but the funding isn't set aside, but that's the assumption.
Okay. Yeah, lots of questions, lots of interaction here, which is great. But thinking about this one's from Lauren, are there any plans to educate judges on the conservatorship law and implementation in Louisville before it begins to roll out?
Yep. Yes, that's on the list. We've been working with the county attorney. You know, I'll say 20. I mean, it is. There's a checklist of things that we've been trying to do, and 2021 is the end of this has gone a lot faster than expected. But absolutely, we've been working with, you know, our county attorney's office is the one that is the attorneys that file our cases for us, and so we've been working with them, trying to get, you know, to the judges to to figure this out. That's also why we were interested in starting with one, so that we could get it to the process and use that as not as a test case, but as a case that we can then use to talk about, you know, what went well and what didn't, and what lessons have we learned.
And let's go to Melina here. She put a question in about, can we talk about the plan that conservators must present to the city and the city must have in the petition itself? What is required of that?
Yeah, so my question here is a little bit like, when you look at the statute, the petition must include some information about the property and what the conservatorship would look like and recommendations for the conservatorship. And that has to all be in that first hearing, where we don't know the parties in interest, but we know that there are some. So we know that there are recommendations that are made at that stage, and then the court can appoint a conservator based off of those recommendations. So that's one area that I'm kind of flagging for the whole group as community engagement rich area, but also like what does that mean? How do those recommendations get set? And then later, the statute also says that while in possession of the building, the conservators shall submit the final plan to the court and all parties in interest. And that seems like another area that should be like ripe for community engagement, community sign off, honestly, where you can have your conservatorship and then through the process. I'm so sorry if the air conditioning unit is loud for everybody, but it's what I have. But yeah, I mean, like that seems like an area where I understand the conservatorship is a process, and maybe through that process you incur additional costs. The affordable housing model that you had, or the land abatement, soil abatement, whatever that was, it's like financially not as viable. So maybe the conservators like, let's do it a different way. I think that final plan should still get some community engagement for sure before it gets submitted to the court, and even the parties in interest, and hopefully all the neighbors as well. But there's those two plans that I've identified, at least in the statute, and kind of wanted to get some feedback on what that process might look like.
So when, you know, one of the other strategies that we have in our office is the land bank, and I see some questions and comments about that. But, you know, one of the things that the land bank does is, this is what we require when people are looking to purchase a lot or a property. It's not exactly the same, but it's similar. We require generally a budget, a plan, proof of funds, a timeline. And then when in the land bank's case, we then do our best to hold people, you know, to hold buyers to that. And so those are the same types of things that we would be looking for when we have, you know, a conservator to recommend to the court. It's, you know, you have this property. There are, you know, some limitations about entering the property. Obviously, we don't own it yet. It's not in conservatorship yet. So, you know, can we get a basic cost estimate by not trespassing, and then go to the court with, you know, here's what we think it's going to cost. Here's what we want to do. This is, you know, it's going to take 6 months. It's going to cost $60,000. I'm making these numbers up. And then, you know, once we get in there, or once the conservator gets in there, then it's, you know, hey, court, we actually added another $20,000 onto that. What, you know, when we were talking earlier about having their ducks in a row, what I would like to see from conservators is a plan in the beginning. I mean, as I said, you know, if it's a nonprofit housing provider, they're telling us we've got a list of 15 homeowners that are going through counseling and they'll be ready and they want to purchase in the Russell neighborhood. And so, you know, our plan is to offer this to this list of people and then go to the court with, you know, with one of those options. So there wouldn't necessarily be a second plan. But to your point, Melina, I mean, if, you know, if the conservator is coming with just the structure plan, then, I mean, you're right, there would be a second plan. Again, under the way we're going to implement this, I don't expect that I mean, things will change, but the plan is, the end of the plan is we're selling this to a homeowner. That's what we want. I mean, that's not necessarily what we're always going to get, but that's what we want. We don't necessarily want this to go to, you know, an investor that's, I mean, a landlord that's going to rent. We know we need affordable rentals, but this kind of situation, we can certainly try to prioritize homeownership.
Okay, that like gives me a good follow-up, if that's okay, Tony.
Go ahead.
So is this entire, like this tool in your toolkit, is it baked into a larger urban planning kind of framework that's guiding at least your department, if not like Louisville decisions generally? And then is that available for all of us to see?
That's a good question. Our department has a strategic plan. The mayor has a strategic plan. All of these, nothing that we're talking about is outside of that. Does everything, can you easily put the triangle with the triangle and the square with the square? Not always, but generally, we want to improve homeownership rates. We want to reduce concentrations of vacant and abandoned properties. We don't want to displace people. I mean, those are, our marching orders, and we do tend to be required to report on them. But is it all in a neat framework? It has been, and it's not necessarily that way over the right this second. But generally, our strategic plan department, which is on our website, and the mayor's strategic plan, this all fits up under there.
Thank you. There's a question from Kelly. Is there a reason Metro is prioritizing land bank over a land trust model that would help better ensure long-term affordability and community control over the land and property?
Nope, other than the land trust doesn't exist right this second. So, I mean, when I said that the land bank would be the conservator, that's literally all I meant, is that the land bank, because it's staffed by Metro, has, the authority to procure contractors, to use funding, I mean, that sort of thing. That's it. That's not a long-term strategy. That's not something that we want to do long-term. But it's most likely, I mean, if we're going to file a case in a month, and I'm not sure that we will, but if we were, that would be the thing that would make the most sense to start with. We are excited about the land trust that is coming in Smoketown and Russell, that rebounds, heading up in Bates. I know that they've done a decent amount of community engagement, but it's not quite up and running yet. But our hope is that there will absolutely be, one or multiple land trusts in the near future in Louisville, and we can hook them into the conservatorship program.
Good. Thank you, Laura. A question here, really going back to the beginnings of this law. Governor Beshear originally vetoed the legislation before it was overridden, citing concerns that the bar was set too low for seizing Kentuckians' property, while also creating housing instability for households during a global health pandemic. How can we be aware and keep our eye on this, that we're in the midst of a pandemic, and what pitfalls may exist that may exacerbate that through a conservatorship law, even if we're only talking a few properties, that still affects people, right? So how are we thinking about that in that larger global context?
Our focus on these properties is really vacant and abandoned properties. And we get, I don't know, thousands of calls a week about people who live next to vacant properties and abandoned properties, and they don't want to live next to abandoned properties. It's scary. They can't get homeowners insurance. There is a risk of fire. There are so many problems with vacant and abandoned properties that a lot of times, if the city comes in and demolishes the property, they're thanking us for it. We don't like to take houses down, but that is a way to remove blight quickly. And I don't mean blight with any other connotation other than a deteriorating property that is scary, frankly. And so, we really look at this tool as a way to turn that property, instead of taking it down and making a grassy lot, which we have plenty of, and turning it back into an occupiable property, preferably for a homeowner. So I think that with that in mind, and with that as a goal, this will end up helping and improving the streets that neighbors who are calling us live on. I think that it'll have the same impact as an unfortunate demolition.
Okay, thank you, Laura. And let's think about, talking about community engagement. What role can advocates play right now? This might be a question for Melina and for Ben, just about engaging individuals, making sure people understand the law, and how they can be aware of this, of this potentially affecting a property near their home. What role can advocates play?
Well, already it sounds like advocates could get Metro or like Louisville Metro Council to adopt like some kind of ordinance, some kind of commitment that gives teeth to honestly like what it sounds like Laura's vision is, with some additional like safeguards and procedural mechanisms to proactively and inherently be protective of community engagement. I think that is something the city of Louisville needs to do in general. But that seems like a really great role for advocates to play, is lobbying our local officials to adopt an ordinance that says, here's how we, the city of Louisville, will utilize this state mechanism to protect affordable housing. And obviously, I would like to see a little bit more about how to use the land piece in there, because even though it's a very clear preference for buildings and structures, I mentioned in the pre-meeting, well, what if there are buildings or structures that are beyond conservatorship? And then that's where the term blight comes from. They've just got to be taken down. Could we have land conservators that then do soil rehabilitation, or in general, like let's earmark that property for a community garden or a park, like let's get the community involved in what should that property be now that the building's being torn down. There's a lot of flexibility in having a local ordinance that says, okay, well, this is what we're going to do that meets our strategic goals.
Billy Holman is asking that we elaborate a little bit on specific bullet points in ways that, because there are a variety of ways in which advocates can be engaged. Are there any more specifics that anyone would like to offer?
I see it's please elaborate, M. So I would say, and from the work that I've done here and the work that I've done other places, this is clearly a place for coalition building. This is a very easy place for affordable housing advocates and then green space advocates or food justice advocates to be at odds for things where it really shouldn't be. It can be a really intentional planning process with the city. That's why I asked about the strategic plan. Using that strategic plan to say, okay, we want affordable housing. There's going to be buildings that are beyond saving. Can those buildings that would be great conservatorship pieces for community groups, can we expand that definition of parties and interests and definition of who can be a conservator? And imagine that the state law is the floor. Can we get it more so that the community's involved? And that takes, research, that takes looking at other models. I know Ben's office has already done that. The Finn group has done a little bit of that. And I know that the city's done it. Like the city has, Laura mentioned, they've looked at other receiverships. Well, let's look at other models and see how Louisville can do better than the state law. And I think that that's just building a team that and just a very team oriented approach. So specific bullet points would be things like meet with your Metro Council and figure out what they think the priorities are in their neighborhoods and tell them, no, these are the priorities in our neighborhood. I live in the Highlands. I've got a great big school with a big vacant yard that kids love to play in. Could I use that land? Could that be up for a conservatorship? No, probably not. But does that mean that I couldn't talk to my Metro Council member and be like, well, why can't I have a space for a community garden on that land? Can we do things other than regularly mowing these vacant spaces? So it's really about coalition building between advocates in this space, and then really sharing as much as we know. Ben knows so much about this law, way more than I do. Laura knows so much about this law, way more than I do. And having that wealth of knowledge come to one of your community meetings and just share, okay, this is what it says. This is what we want to do with it. And then you take it to your Metro Council member and say, okay, this is what we want to do with it. Write it into law. Thank you. That's your job.
I used to like being part of panels, and I don't anymore because there's always people in the chat that know more than I do. And I just want to point out that Eileen Ordover from Legal Aid Society educated me. I put it in the chat, but I do want to flag, because I said this and it's wrong. I said that neighbors don't have a right to intervene. That's technically correct, but the statute does give them the notice that they have to provide, the city has to provide, is notice that they have the opportunity to intervene, and judges have the discretion to decide whether or not to allow that person to intervene or not. You know, what I said in the chat, I'll say here as well. Because we have so many absentee landlords in the West End and around these vacant and abandoned properties, I mean, I have surveyed with the help of a legal intern, Pierre Stevenson, last semester, surveyed who owns the properties adjacent to some of these properties for sale for $1 for side yards. And it's, you know, less than 30% of the properties have neighbors that appear to own the property next to the vacant property. In other words, if we want to make sure that those properties go to people who actually live in the neighborhood and who have been affected by vacant and abandoned properties in the West End, there's a limited number of people that we can give those properties to or allow them to purchase it as a side yard for $1. And so just giving notice to neighboring property owners is not going to get the community input that everyone on this call, I think, wants to see, and the community engagement. But I'll just say this: the county attorney is the attorney for the county, right? The county it's his or her client. And so Metro Council can tell the county attorney what to do to some extent. Now, I'm an attorney and I'm not going to take all my marching orders from my client, but there are some things that the client gets to tell the attorney what to do and how to do it. And if community engagement from actual neighbors, not just neighboring owners, is a priority for city council, they can find a way to that solution. To you know, on its own, require the Office of Housing provide door knocking services, or at least postcard notice to neighboring property owners, or notice to the president of the neighborhood association in the affected neighborhood, or whatever it might be. There can be additional safeguards put into place by Metro Council. Now, that opens up a whole other can of worms in terms of, like, has the state legislature preempted the Metro Council from requiring additional things? You know, that would only come up if the mayor wanted to object to, or the county attorney wanted to object to the involvement, greater community engagement involvement. I would hope that no mayor would buck that, right? But those opportunities for greater community engagement are there. But I did want to sort of fess up that I got that wrong and Eileen is right. Eileen, do you want to stop in here? You can just take over for me.
Well, we have come to the end of our time, a few minutes over here. I just wanted to take a moment and thank everybody for participating as an attendee, as a panelist. A lot of robust discussion going on here. As I said before, we will follow up with some questions that we were unable to get to tonight. And the event recording will be available on MHC social media and on the MHC YouTube channel as well. And we'll make it available in the next e-newsletter as well. So thank you for attending. Thank you for this robust discussion. And I think it is evident that the discussion will continue for sure as this is implemented. So thank you and have a great evening, everyone.